like to welcome you here and thank you for coming out despite all the weather. My name is John Wade. This is the third in a series of breakfast sessions dealing with mini topics within negotiation. I'd like to thank again the Law Foundation, the College of Law, and Laurie Sarowski for setting this all up. In theory, you should have in front of you three things. You should have a paper and also a yellow sheet of paper and a small cue card. So if you put your hands on those, we'll refer to those at various times. The paper has also been sent to you electronically if you've registered. Please wave if you can't hear, or can I just ask the people up the back, can you hear? Okay, great. And please wave if the sound drops out or anything like that. The title of today's session is, you'll see from the paper, Systematic Risk Analysis for Negotiators and Litigators. You could add and mediators and parents if you like, and how to help clients make better decisions. So this is a practice that you all do already, and you all do to some extent if you are lawyers. Could I just get hands of those of you who are lawyers, please? Yes, so the majority of people. So you would do this already to some extent. And we all do it in our lives. What are the pros and cons of buying this car? What are the pros and cons of marrying this person? What are the pros and cons of going to a judge to have a decision made? So what I'm going to encourage you to do is to take the to some extent that you already do this and turn it into a more systematic pattern. And I've done this for a number of years, for many years as a mediator, and it's become a very helpful thing, in my opinion, for clients. Many clients come back and say, we'd like to do this again, and I'd like you to develop this practice so you could do it tomorrow at your work or in your decision making about buying X or Y or moving to such and such a job. None of this is rocket science, and you'll see from the beginning of the paper there are some footnotes to the many other disciplines who deal with this. They would talk about a cost-benefit analysis. There are many good reasons not to do this as the paper goes through, but I will try and debunk those reasons for you. The paper has three parts. What is a risk analysis? And then why is it essential? And then why are the good reasons not to do it? And then there's a bunch of precedents in there for you to cut and paste and use in your life. There'll be two exercises during the course of today, so it'll be a little bit different from other sessions in that you need to work even at this hour of the morning. Okay, so what is a risk analysis? I'll refer at various times to pages in the paper. Particularly lawyers enjoy having affidavits in front of them, is my experience. So, page 2, what is a risk analysis, at least in the way it's being used in this paper? It's something in writing. We often give oral risk analyses to clients or to self. It uses client language and diagrams. Many clients are visual learners. They love to have little diagrams. If possible, it should be short, down to 1 page, remembering that for many clients this needs to go on their refrigerator and sit there for a few weeks so that their relatives and their friends can read it. It needs to be evolving and dated, because you'll see later it's very important for self-protection, for lawyers who are trying to protect themselves against professional negligence actions from clients, or clients who said, you never told me, so a date on it. And some lawyers get their clients to sign this document. It should talk in percentages, in ranges, never in rights or justice or reasonable. It should talk in ranges of good day, bad day outcomes. And it should include legal risks, personal risks, and business risks. Very important not to just focus on legal risks. Over to page 3. One of the benefits for me of being a mediator is I get to observe many people making decisions and try to assist them to make those decisions in the face of some uncertainty. We did a survey at Bond University of 40 of the most employed commercial mediators. They came away with us for 2 days, and we did exercises and asked them to fill in questionnaires about their lives. And you'll see on page 3 that these were their critiques of the lawyers who often appeared with them, before them, getting ready for negotiations. And these were the four most common critiques. A lawyer who's given wildly optimistic advice, a tendency to concentrate on legal questions and miss the personal and commercial goals of clients. Lawyers, interestingly here, who'd become emotionally involved in their client's own cause. And finally, what's known as entrapment, the trap of committing too much to a particular cause and therefore having difficulty from withdrawing from it. So it's expenditure in cost and time. So if you need to make a good decision, you need to avoid those behaviors and try to define the costs of that decision and the cost of alternatives. Absolutely essential to say, what are my alternatives? So you'll see on your little card that this is a great card. I've often used it late at night, stuck to my phone as I'm preparing people for mediations and fairly exhausted, so just use some of the questions here. Question 13 has these horrible acronyms, Watner, Batner, and Patner. So that's a cost-benefit analysis. What's the worst alternative to a negotiated agreement? So what's the worst if we work out of here? Batner, what's the best alternative? And Patner, what's the probable alternatives, to try and weigh up the ranges, not the rights or the justice. So this paper is hidden in point 13 of the preparation card. And you'll see on page 3 this great quote from Roy Lewicki, who is one of the social psychologists researching for many years into negotiation. Bottom of page 3, you'll see there, while success in negotiation is affected by how one plays the game, the most important step for success in negotiation is how one gets ready for the game. Although time constraints and work pressures may make it difficult to set aside the time to plan adequately, the problem is that for many of us, planning is simply boring and tedious, easily put off in favor of getting into the action quickly. So preparation is the engine room of negotiation and mediation, and the actual meetings or the Skypes or the phone conversations are just role plays that are played out after good preparation. My experience as a mediator, bottom of page 3, is that lawyers are excellent at defining three risks. Delay, this will take 18 months to resolve. Excellent at, or between 18 months and 24 months. Excellent at defining out-of-pocket legal expenses. Our expenses will be between $75,000 and $150,000. Excellent at that. And then uncertainty. We don't know which of these 4 judges we will get. Each of these judges has a particular predilection and a particular focus, and therefore we live in uncertainty. We live in uncertainty of whether witnesses will turn up, whether witnesses will look good in witness boxes. So out-of-pocket costs, delay, and uncertainty of the judicial system. And they're excellent at describing that. And you can ask lawyers to write those out in 3 sentences and they can do a brilliant job on those 3 risks of the alternative of going to court. Often these risks are described with vague language such as danger, no guarantees, no one can tell, it's all a lottery, it's brain surgery with an axe, those kinds of statements that people say. Rarely, in my experience, in legal culture, was I trained to use one page to set out the risks or to expand the risks. Okay, so I'm now going to get you to do an exercise just to keep you focused on this. This is a mediation that I was involved in. The names have been changed, and this involves you using the yellow sheet. Please pull out the yellow sheet. So this is how the dispute evolved. There were 2 good friends, Paul and Michael. And Paul and Michael entered into a partnership, a very successful partnership, building houses, hundreds and hundreds of houses. You might want to take some notes about Paul. Paul was a workaholic, a detail person, a surveyor, an excellent designer of houses. And he made a great partner with Michael. They were best friends. Michael was an entrepreneur, what we call in Australia a white shoe brigade person, who looked very polished and made contacts with people and bankers. So together they built hundreds of houses. And then 2008 came and crash. the housing market fell, and so they engaged in what we learned about last week, attributional distortion. Instead of blaming the global financial crisis, they blamed one another. So Michael, the entrepreneur, said, Paul, you're not focusing enough on your work. You're not on the site often enough. Paul said, you're hanging around with wealthy bankers too much. You're not focused on your work. So they began personal blame, and eventually Michael shut Paul out of the business, changed the locks on the business, and they went to lawyers, and lawyers turned their dispute into legal categories. And the legal categories were that Paul claimed $1 million from Michael. What did he claim $1 million for? Well, he was meant to get $1,600 for each house that he designed. He'd never been paid that. Likewise, he'd often worked overtime. He was a real workaholic, real focused person, never been paid for overtime or his design of houses. When someone makes a claim, what does the other person do? Counterclaims. So Michael did put in the cross claim for $600,000. Why did he put in that claim? Because he alleged that Paul, on multiple occasions, Paul had been building his dream house, that Paul had diverted subcontractors from their business to help with this dream house. So Paul and his wife had been working on this house, and Michael did the maths and said, you owe me $600,000 for diverted subcontractors. And so they came to a negotiation, it was a mediation, and at that mediation they had two outstanding lawyers acting on their behalfs who wheeled trolleys full of documents into the mediation room. And these were the histories of each subcontractor working, and these were the histories of each event, how many houses Paul had designed. So as a mediator, part of my practice, part of my alleged value adding to work on this was to prepare a risk analysis. So you have a version of this. Now this is very unusual. The same document was prepared in blank for both the parties. Why was that done? I can't remember exactly. I think it was because of an aeroplane trip and being very hurried. So I gave them both this document and said, go home and you have 5 days to work on this. And so they worked on this document and they monetize each risk. Notice the final column to the right. How much would you pay to avoid the risk? This is one of the key parts of the exercise, to turn values into money, because until they're turned into money, you can't do a strong analysis of, well, how much would you pay to avoid stress for 18 months? Give me a number, give me a number. How much would you pay in order to open your new business in Shanghai in the next 18 months? Give me a number. So what I want you to do is going down the middle of the room with Glenn at the center, so everyone over here to the left. I want you for 2 minutes to guess at what Paul, the workaholic, the focused person, the excellent surveyor, would write as his risk, because he's gone away with this, what he will come back with. He's going to rank his risks, numbering the ranking from 1 to 10, not important to very important, and then he's going to try and monetize it. And everyone to the left of Glenn, or to my right, I want you to work on behalf of Michael and to try to guess at what Michael will come back with on the day of the mediation or the negotiation with his risk chart. You have 2 minutes, go. You can talk if you wish. I'll give you more facts. These pair were best friends. Michael had been the best man at Paul's wedding. They both had opened an orphanage in Somalia and had used the massive profits they got from the building boom to support this venture. They both went to the same church historically. They now went to different churches. Next procedural bump, Paul says, I'd like to bring my wife to the mediation. Why? Oh, she's suffered a lot. She heard the conversations over the years. She'll be a great witness to show that Michael's a liar. Next procedural bump, both the pastors of their new churches phone up and said, we'd like to attend the mediation. Because we know a lot about the history of this family. We know a lot about what they've been through. We'll be very supportive. We should be there. Okay, I'm going to stop you in 20 seconds and I'm going to ask for participation. Okay, over on my left, we have the group who've been trying to guess the risks and goals of Paul. Paul, the workaholic, the outstanding designer of houses, and building his own mega mansion, dream house with his wife on the side. What do you think he put down when he handed in this sheet confidentially to the mediator? I need some thoughts. Anyone call out, please? And when you call out, please call out the number of the risk on the sheet as well as what it is. So,
risk number 5, 10.
Risk number 5, diversion from important work for 2 years. He said, no, I just got another job, not a problem for me. 10 as well? Was that the other suggestion? Yeah, more?
I have a suggestion that you move the mic pointed more towards your mouth.
Great, better?
Thank you.
Excellent, thank you, that's a good suggestion.
Number 9, I gave a 7 to.
Okay, number 9, bankruptcy.
No, bitterness. Bitterness till mutual death.
Oh, okay, bitterness till, number 9, okay. Said no problem for me because I don't like him and we've said bad things, we'll never be reconciled. So I've got on with my life. I'm a most employable person.
Number 11, I thought would maybe be even a 10.
Number 11 is subpoenas and inconvenience for business associates as witnesses. Paul says, no, I'm well connected in the business industry. No, not a problem for me. So his number written in there was negligible or 0. More please for Paul. As lawyers, you're making decisions every day for clients on the assumption you know their interests and goals. On the assumption you know their interests and goals. You know about legal costs, you know about delay, you know about uncertainty of the legal profession and decision makers. Okay, while you reflect, we'll go across to Michael's, please. Michael came back and he was a true entrepreneur. He said, John, this is a fantastic form. You should patent this and make a lot of money out of this. So he was Mr. Flattery. He understood flattery well. So what do you think, Michael? He's the entrepreneur, well-connected, wears great clothes, good suntan, knows the right people. What does he write? It gives you back the risk sheet. What are the risks if this conflict continues? Michael's, please.
I put a number 10 and 14, but based on the things that you said, I suspect I'm wrong.
Okay, number 10, increasingly alienate friends and pastors.
No, I number 14, I felt he would rate that the highest.
Okay, so number 14, lose control. Business people love control, so it's a risk when it goes, you give control to outsiders. He had ranked that very lowly and monetized it very, very lowly. More Michaels, please. Right.
Number 3, I thought that might be very important in future business.
That was of marginal importance, but he had been through many ups and downs, many global financial crises, so he had the view of, as entrepreneurs do, is I can live with the ebb and flow. I'll make friends, I'll make customers in the future. So not a big risk for him. More Michaels, please.
Number 4.
Number 4.
Thought that'd be 7 or 8.
Yeah, so number 4 is interesting. I'll come back to that in a moment. Any others? Number 4 is the ridicule of Christians. You're just as bitter as everyone else. Anything else? So which do you think the lawyers were there at the intake sessions, again, confidentiality, which do you think they would emphasize as the risks? 6 for sure. You will have to pay this range of costs. So lawyers great on legal costs, and we have to go to different venues because there are some employment topics here as well as contract topics. They were a bit concerned about 7, that whatever remedies you got would lead to bankruptcy and you would never collect. So what's the point of getting remedies? There may be double bankruptcy here or 1 bankruptcy here. 13, yes, get paid 0 or less, so lawyers have that concern. So lawyers have a different risk analysis, and that is a helpful risk analysis. Okay, so what happened in reality? First, let's go back and leave you in tension. What are you going to do about the procedural request of the wife to be present? Remember his reason? She's a great witness. She'll be able to show Michael's a liar. And I need the support. And we're building a dream house together, so she knows how many subcontractors came across and at what times and whether they were diverted from key work. Okay.
Maybe an important decision maker.
Yes, she may be a very important tribal decision maker, so that's one of the topics we look at next down the track. So she may be. So if she is, what are you going to say to Paul and Michael? Okay, Paul, she could attend. I don't like the way she's going to be used as a witness to show that Michael's a liar, but if she is a key person in your life, now what are you going to say to Michael? Hello, Michael, phone. We've got a wife who would like to attend, Paul's wife. What's Michael going to say? Okay, first response, I want equal numbers. Second response, no. Third response, why? Where will she sit? What will she say? I don't like her. So Michael went through all those routines. I don't want it there. So you have to push and say, well, what if? Remember the great phrases. What if she is a key decision maker? What's the point of having her in a strange place where we have to talk to her later? What if she was present? What if she was at the back of the room? What if she was not allowed to speak? What if she could only speak when asked? Don't like it. So you push Michael, and what if she came? Would you like to bring anyone? No, I'm a strong entrepreneur. I'm a big boy. I don't need people to back me up. Okay, so what are we going to do? So in the end, push. What if she was present at the back of the room, can't speak? Yes, okay, I'll live with it. Don't like it, but I'll live with it. What are you going to do about the pastors? We'd like to attend. We know a lot about these people. We'd be very supportive. Could be key decision makers, could not. So, different decision. Made it on the fly. Thank you very much. Please be available on your mobile phones all day. Will you speak to no one else on your mobile phone so that we can consult you? Yes, good. All right, back to how did they fill in the sheet? Paul filled in the sheet, and he had his wife sitting next to him as he came and gave the sheet to me. Now, number 8 was the key interest of Paul. As he began to talk about it, his wife rammed him in the ribs with her elbow and said, tell him the truth. And he mumbled into his shoes, I've had 2 mild heart attacks. And my wife said she doesn't want to be married to a dead person. So he hadn't put the money in, so he said, I'll put in 200,000 there. His wife said, double it. 400,000 in the monetizing what I'll pay to avoid the risk of more stress. This is the workaholic who's just got another job. As for Michael, he'd ranked everything as low, except number 4. He said, I will pay anything to avoid being a hypocrite. I will pay anything to walk the talk. So he had written the sign infinity in the monetizing. So you knew you were going to get a settlement, right? 1.6 million gap, 400,000 move straight away for health, and infinity move on the other side. So they negotiated for another 8 hours, making incremental moves. The wife was the key to the settlement because she spoke graciously when asked. She didn't engage in hacking and criticizing. She engaged in brainstorming, and the final deal, what do you think it was? Michael paid?
Michael paid Paul, yeah.
Yeah, Michael paid Paul $43,000. Michael, in his good entrepreneurial way, said, "Oh, thank you for the settlement. I've packaged up all the photographs and records of the Somalian orphanage, and you can have them because I know it means a lot to you. Good set of steak knives to seal the deal." And the mediator said, "And what are you going to tell the tribal groups?" So we drafted a statement for the tribal groups. Very short. "We have had many difficulties in the past. We have met together and resolved them." That's what you tell the outsiders. No more, no less. So that was part of the deal. All right, why is a risk analysis, page 4, so important? So that is meant to teach you that presumptions make fools of all of us. Presumptions make fools of all of us. Question, Kat?
When you actually get this kind of information, apart from it being trying to evaluate how far they're apart and what they're willing to do to get out of it, what about the information itself? Do you utilize that in the mediation, or just allow it to come up naturally?
No, on the model of mediation, the question is, can I use the information that's come up in these confidential brainstormings of risk analysis? The answer is no. I know that it's worth persisting, though, because they both have risks, which they've been willing to identify, and this has helped them identify it, because the lawyers were astounded. They love this, because suddenly, instead of a long piece of litigation about legal rights and evidence and facts, very complex, their clients had identified other commercial and life goals. So the lawyers were really great, and they played a role of just, whenever someone raised a legal argument, they'd lean forward and say, pull out a folder and say, well, here would be my arguments if they were necessary. Then they'd slip back. So the answer is no, you can't use it consciously. You can beat them up in private session, but you told me, but you told me, but you told me. And that's necessary at some point to say, use their reasoning to beat them up. Not my reasoning, their reasoning. So it's used again and again in the meeting, but in confidence. Okay, so page 4. Why prepare this? You've just had an exercise doing it. I'll take you through these reasons quickly. I've been convinced by my own reasons. All right, first, and these are reasons you'll see in all kinds of literature, particularly medical literature, to do with making decisions about treatment for cancer. First, there's an old adage in decision making, garbage in, garbage out. If you don't define risks and goals, both conscious and subconscious, and bring out the subconscious, then you will make decisions based on false data. Garbage in, garbage out. Often lawyers say to me, oh, I need to get my client's instructions. Well, that's often a cop-out. The client needs to give instructions and be told what to say. The client needs to be told what is important to put into the giving instructions process. It must be what's called informed consent. How can you do informed consent until you know your life and commercial goals? Next, last week we looked at the so-called psychological traps of decision making, absolutely well documented in thousands of studies. Psych 101. Human beings, we are wired to make bad decisions. We are wired to make bad decisions. Law school treats us as if we're rational enough, we won't. That's just clearly not correct. We have these decision traps, and we looked at them before. They're set out in many books. This is one of the famous books which discusses them, but now they're in all kinds of pop books as well. So here they are. They're set out, the anchoring trap, the sunk cost trap, and so on. We looked at these last week. So if human beings are wired to make bad decisions, that's us, and we're wired to use some of these shortcuts, which are sometimes helpful, but sometimes are disastrous, Then, we as human beings need assistance to attack those particular presumptions. We need the court jester, we need the village idiot, we need the skilled helper to say to us, have you thought about, have you thought about? And so the risk analysis gives us one of the mechanisms to do that, as you just saw with Paul and Michael. Next, page 6. At least in Australia, we live in an era of lawyers being criticised constantly with professional negligence actions, with reports to law societies, and then to have a he said, she said sense of defence. But I told them, but we talked about. It's essential that you have a written defence, a risk analysis. We discussed the risks. Here is, it's dated. This has been updated 3 times. Next, clients have selective deafness. In many training courses, you teach that clients hear every 5th word that you speak. It's very sobering. If you run a tape of yourself and cut out 4 words at a time, just think of what's left. It's a kind of a beep, 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 and that's what they hear. So as clients hear selectively, it's essential to try to give them a document that they can reflect upon, particularly so they can take back home to their constituents, to their CEO, to their accountant. So this paper, piece of paper, can be reflected upon. Here are the risks and goals of my life. One of the challenges of being a negotiator, on the bottom of page 6 you'll see there, is that negotiators need to deliver a double message. I am a Doberman, I can attack, I can be assertive, I can be the bad cop, but today I can be the good cop. I can be a diplomat, I am schizophrenic. So how do you deliver the double message of being aggressive and yet understanding risks? And one of the answers that helps you is to have a risk analysis which you can wave around. So here's some of the risks of litigation. They're set out in detail on page 28. You may need this as a handout in your law office or in your HR office. The critiques of litigation and adjudication are overwhelming. Certainly in Western democracies, they're better than vigilante justice and having someone knock on your door at night. But nevertheless, for businesses, these risks are well documented, and you need to have a one-page sheet to give to clients. This is what you are buying, and do you want to buy that? Next, bottom of page 6, I've seen this used extremely well as a routine. A lawyer sits on one side of the table and has a sheet of paper which he or she waves, and they say to the other side, we've done a risk analysis here, just a one-page risk analysis. Of course it's confidential, they're waving in tantalizing fashion. And then they put the knife in and say, and I assume you've done the same for your client. Long silence, because the other client didn't get that set of steak knives at all. Didn't get that risk analysis, just got a blah blah. And they can't even remember what the blah blah was. And so the lawyer waves this particular sheet of paper and turns it upside down and puts it back into a file and says, having done that risk analysis, we may have made some mistakes, but we're open to listen to you to see whether we've left anything out. And we will revise our risk analysis. Very powerful kind of game playing that's done, as well as helpful game playing. Next, we live in a growing era of accountability for medical profession, for any profession, for architects, for lawyers, and we need to be more than just Dobermans and good drafters of documents. Lawyers are superb drafters of documents, but we also need to be doubt creators for our own clients and to help them make wise decisions in the face of uncertainty. And we're adding value. At a time the legal profession is shrinking, we need to find ways of adding value. So those are the good reasons, and I commend those to you. Why isn't it done so often? So why are these kind of written risk analyses so uncommon, at least in my experience of meeting people culturally in Australia, Canada, the United States, and Indonesia? Here are some of my attempts to try and understand why this is so unusual when it's such a good marketing point, when it's so helpful to clients. So I'll take you through these and you can read them in more detail. We'll go through them a little in machine gun fashion. Habit. John, that's not what we do in Indonesia. No training. No one ever taught me how to do this. I didn't have a master solicitor who did this. I haven't seen it done, so I don't know how to do it. Next, expense. This costs money. This is going to be X billable hours to sit with a client and do this. Just so you know, I'll give you some of the rebutting of that. You can do a risk analysis on the back of an envelope in 10 minutes, as legal aid lawyers do when they go into negotiation with a client. But nevertheless, people say this is the boring preparation for which I have to charge. Next, bottom of page 7. This is an exhausting experience, trying to educate a person about their life goals and their commercial goals. They don't do it themselves when they buy houses or get married, so why should I do it? Why should I take them through this exhausting process when they are fixed with Robert Benjamin's myths, the myths that the court system is rational, will find the truth, will be final, and so on. Next, John, we don't do this because this will scare clients away. If I wrote out the list of driving a car, you'd never drive a car again. And the medical profession struggles with this scaremongering when you see the one page of fine print on the risks attached to taking this particular pill. Next, I'll lose the client. If I sit down and take them through the downsides of this course of action and get them to articulate their life goals, I'll lose the client. Next, attached to that, many clients are not ready to hear these hard truths because they've just lost the farm, lost a leg, lost a child, lost a spouse, lost a business. So in the grieving process, they don't want all this cognitive information about pros and cons, cost-benefit analysis. This is a harsher version, page 8 of that, is that, well, John, human beings are irrational in any case. So we all make decisions. We're 60% irrational, 40% rational. So I can't overcome the irrational side of my clients. Just go with the flow, and maybe they'll become rational at some later stage. Next, very common objection from US lawyers is this risk analysis, John, is way too dangerous because in the age of email, people can press CC, people can press copy, and suddenly our profound risk analysis is in the hands of other people. Next, John, I work in the field of interlocutory injunctions. I work in the emergency ward. We have to race off to court with an affidavit and get a short-term order. We don't have time to sit around and do this nice risk analysis. I will look at the risk later. I've got to get an interlocutory injunction this afternoon. Next, this is a very common one. How can I give a risk analysis till I have, and here's the dangerous phrase, all the facts? All the facts. We need to get more facts and then we can do the risk analysis. And that is a common statement. I think it's a dangerous one because you date your risk analysis and you put on it based on the facts that the client has brought up in this last half-hour interview, and this will change as time goes on. Next, fear of inaccuracy. We don't put this out as a risk analysis because we could get it wrong. We don't want to have evidence against ourselves that we got a poor risk analysis. Next one. So that particularly, you'll see some American lawyers say to me, John, we put nothing in writing so we can never be proved to be wrong. It's the defensive mentality of having clients turn upon you. You try to minimize the evidence trail. This one is an important objection. So this is what the medical profession faces also, is if you try and systematize this in your practice, in HR, in building, in law, you may end up with a standardized list of risks, of 27 risks, just like the one on page 28 of the risks of litigation. And once they're standardized, people don't read them anymore. It's just fine print, and so they become sterile. It's not informed consent, it's just another list which we go, tick, I've read that. So that's an important objection. Next one, some lawyers say to me, is the main things I've got to say in my risk list involve bad-mouthing judges, because the court system is inherently flawed, as page 28 lists. So John, I don't want to put out a public document which could later be turned against me if a judge ever read it. I need the favour of the judges. I don't need to be known as someone who calls the judges attached to particular, this is a phrase that my class had never heard, hobby horses. Ever heard of that? Hobby horse is a particular fascination, a particular topic that a judge decides to fix upon. So I don't want to be seen to be putting down people from whom I will need favours in the future. Next, this one, I'm a lawyer, not a counsellor. This is all touchy-feely stuff. Personal goals, business goals. I advise people on legal risks, not all this touchy-feely stuff. Next, this one's particularly dangerous, and I don't know that many people still use it, is that they hired me as a wise elder. They put their life in my hands. I am the white knight on the white charger. I should not induce doubts in their lives by bringing up certain cost-benefit analysis. I should take their lives and run with it. That's just begging for professional negligence action, but nevertheless that is an attitude that's still around. Next, oh John, we don't do risk analyses in our firm because the mediators do that a year later when we go to mediation. Or in Australia, the barristers do it 2 years later at the door of the court. And so they try and protect me later by saying, I know your lawyer probably told you this, but I'm telling you this again. Here are the risks if we go ahead. So very good reasons not to do this. And nevertheless, I say to you that the 8 reasons to do it trump the others, and that this is a good systematic practice. So what follows from page 12 onwards is a number of precedents which I encourage you to cut and paste and plagiarize, number of examples of the kind of risk analyses, how to monetize them, how to put a chart where they prioritize them, which is the most important, and some examples from mediations that have been done. I'd like you to turn now to page 20. Page 20. And you've already done this to some extent with Paul and Michael's example. But the flip side of risk analysis is life goal analysis. So every goal has a risk, and every risk implies a goal. So you see at the bottom of page 20, if someone says there is a risk of 2 years of delay, my goal is to fix this soon. If someone says that the conflict will bring stress to my family members, the goal implied is to minimize stress for my family members, for my colleagues at work, for the other people who might become involved. If a risk is legal costs between $30,000 and $60,000, the goal might be to spend that money elsewhere, to minimize legal costs, and so on. You can do a very helpful double chart. Risk turned to goal, goal turned to risk. Now clients love this. It's said that business people are more persuaded by goals, lawyers are more persuaded by risks. There's no real research to establish that, but there's lots of research to establish that people are more persuaded by loss than by gain. Lots and lots of research. So you need to become a professional manipulator of language. You're saying the same thing. There is a risk that we will need to subpoena your grandmother. The goal is to give your grandmother a peaceful old age. Now, during negotiations, you need to convert as many statements to gains as possible. We have made the gains so far, so far, so. Do you want to risk losing them? That's far more persuasive than to say, oh, we're still short of your goal of $1 million. The question for Paul and Michael is, you told me your goals were, if we settle today, we have achieved them. Now, do you want to risk losing them? You say to me, John, this is all word games. It's not. The research is absolutely overwhelming. Human beings are more persuaded by risk of loss. Give somebody a pay rise and then try and take it away. The loss is very devastating. That's why people are reluctant to give to employees, because if they think they're going to have to take it away, they know they're going to have extremely disgruntled people. Loss is more persuasive than gain. So you need to become, with this risk analysis, also a goal analysis person so that you can manipulate language back and forth. I'll try and give you an illustration of this. This came from a matrimonial property dispute, just to try and turn the concept into concept. So this is set out on page 22. So here was a risk analysis that had been drawn up for this lady during the preparation for the negotiation. And predictably, when you went to the negotiation, when she was negotiating about numbers, the numbers were disappointing for her. She wanted $540,000 after a long period of negotiation. The offer, the final offer, the bottom line, all those kind of jargons got to, was 500. So she was 40,000 short of her goal. So you could have defined the whole negotiation of, you are short of your goal. You have a goal and you're short of it. Instead, a risk analysis enables you to define her life goals, because she's done this before the meeting. So you then meet with her and say, well, so far today, you have had 14 goals. We have achieved 13 of them. We have achieved 13 of your goals. Let's go through the ones we've achieved. And then to get on with life, by 4 o'clock, you won't have to think about this. You'll be able to sleep at night. If you want to open a new business, you'll be able to open a new business tomorrow because you'll have some capital and you'll be able to get a bank loan. You'll be able to invest money because you'll have money in the hand and compared to money coming in. You'll stop paying lawyers. That's a goal you've had. You will stay healthy. You're very stressed by this ongoing conflict, so you are going to be, the beginning of your health rise starts at 4 o'clock this afternoon. You want to minimize contact with your husband because it's been very traumatic. You want to reduce stress on your colleagues. A number of your business colleagues have been subpoenaed. You want to take a holiday. So you can now take a holiday as of 4 o'clock this afternoon. You can focus on your work because you have been diverted from inventing mousetraps because of this ongoing conflict. You can avoid becoming personally bitter, which was one of your goals. You were finding you were becoming a bitter person and you were starting to dislike what you saw in the mirror. You can focus on your work. I think I got that before. We're doubling up on these. You can regain control of your life. You feel like your life has slipped away to be controlled by valuers and lawyers. The God professionals have taken over. You wanted to settle in the range. These numbers, your lawyers have told you, are in the range. You want to reduce risk of paybacks from your husband because he has various leverage to give paybacks via the children or via business contacts. So we've got 13 goals have been met and we're short on one. So do you want to risk losing 13 to pursue $40,000? So that's how the language is changed. Rather than starting the sentences, you're short $40,000. And I encourage you to engage. You say, oh, John, this is manipulation. Yes. This is improper manipulation. No. It's assisting people to redefine their life and personal goals. Okay, so page 23, conclusion. This topic has briefly set out a description of a kind of risk analysis. Remember, short in writing, ranges, monetize the risks. The reasons why this is very important in a modern era to do. A whole lot of reasons why it's not done. Reasons to avoid this practice. And I'm encouraging you to let the former set of reasons win the debate and for this to become part of your habits. Like tomorrow, every file you're dealing with has a colored sheet of paper, or if it's all computerized, has a particular asterisk sheet of paper with a date on it, which is the beginning evolution of a one-page risk and goal sheet for a client. And I think people will resist you culturally for the reasons 1 to 18. They will say this is stupid, this is a waste of time, this is dangerous, this could leak, all those things. You acknowledge all of those, but say this will mark my practice as being something special, of being of particular assistance to clients. So I'm going to give you another exercise to ram this home. Go to page 26, please. So this is another mediation I was involved in. I was involved in it as a person asked to find a culturally acceptable mediator. I failed completely. So husband and wife, they were both Chinese, they separated. She was 36, he was 45. They're 11-year marriage, but there were no children. He is a very successful Chinese doctor, very successful in his own culture. He's seen as a hero who has become a prominent figure because of the success of his practice. She ran an importing shop which was financially unsuccessful and had been over a number of years, almost become a hobby. So you see on the board, husband's a distinguished doctor, revered by the Chinese community. He has many supporters, so they'd been to a number of skirmishes in court, interlocutory applications, and the supporters turned up and behaved improperly in court, as it turned out, but nevertheless they cheered him on and had denigrated her as the witch. He's paid his lawyers in advance. She doesn't have enough money to pay her lawyers. She's deep in debt to her lawyers in this particular conflict. She is isolated, doesn't have any friends or many friends, and she's very emotional. The attempts to organise a culturally appropriate mediation failed because she had become, if you like, a modernised Chinese woman, and she wanted an independent mediator. He was still attached to the traditional Chinese community, wanted a relative to be a mediator, so he couldn't bridge that gap even after suggesting co-mediation. There are all kinds of escalations occurring in the courtroom. The tribes have blamed her for the failure of this relationship. There are allegations of missing assets, forged documents, and the parties are $40,000 apart. That's all. They've negotiated. The husband has employed a large team of lawyers known to be aggressive litigators, and they have negotiated. They're $40,000 apart, and they can't get to a deal. The hearing is in 8 weeks' time. Turn to page 27, please. Once again, dividing the room. The tables on this side, could they write a risk analysis for the wife? Page 27. Write out what you think will be her risks and convert them into goals on the other side of the page. And then think about advice you're going to give her. You've got 3 minutes to do that. The other tables for the husband. What do you think are his risks? What are his goals? And what would be your advice in the light of your chart? Now you're guessing because you can't interview either of them. But these would be confidential interviews of each of them. 3 minutes, go, please. So wife on this side, husband on this side. Okay, 20 seconds to go. Okay, start with the wife. Could you call out either risk or goal on either side of that chart? Fire. Poverty, okay, so the risk of poverty, both debt to lawyers and a poor court outcome. And she has a life goal of having some capital, of having an income stream. Okay, more?
Isolation.
Isolation. Extreme social isolation is the risk. As the conflict goes on, she'll be increasingly labelled as the evil partner by the Chinese community because she's up against a hero. Her life goal is to have some supportive social contacts. More?
In a traditional court fight, he would have more money, more power, and she was more even playing field for negotiation.
Great. Okay, so in a court fight, she can't even pay her lawyers. She has the risk that the lawyers will drop her, even with the ethical dilemmas attached to that. So risk that you would be isolated in a court action, and he has a lot of money, paid his lawyers in advance, lawyers known as aggressive litigators. So her life goal is to have a more equal playing field in that power imbalance. More? There's lots more, so we'll go to the husband. You should get to about 10 for the wife. Okay, husband.
Loss of respect.
Loss of respect. Can you just elaborate, please?
He could lose his position of great respect in the community by appearing to be a bully, unreasonable, and all of that sort of thing as his wife's position diminishes.
Okay, so you just have to be careful of that, because in the Chinese community he was a hero because he was showing that she was evil, she was a bad person, that she was irresponsible spouse. So he could lose respect, but it won't be because he diminishes her. It's going to have to be for some other reason. Okay, so you could put life goal, respect, but how is that going to, the risk is, what is the risk? It's not putting her down. More? A poor court outcome. So that's great. So risk is that a court may be particularly sympathetic, equitable property distribution scheme, that the court may give a larger award to the wife than the $40,000 gap. More?
That would feed into the loss of respect thing, maybe.
Yes, so he could be seen as an unwise litigator. But once again, remember, we can rationalize these and say, stupid judge, she was an evil person, but the judge got it wrong. It's easy to rationalize that. More?
How about a criminal charge of forgery? Like, that just speaks to me.
Okay, great. So risk is that out of this particular dirty washing, there will become other events. That is the risk. The life goal is to avoid those kinds of events. Right. Given the time, do you want to know what happened? Yes. I'll tell you later in a couple of months, okay? All right. What happened is they weren't able to get across the $40,000 gap. The case went to litigation. The trial lasted 5 days. The judge reserved his judgment and then wrote a very long judgment criticising the lawyers for their failure to negotiate a deal, saying that this was a deep problem for the legal profession to litigate these kinds of cases, that proportionally they'd gone out of control. So the lawyers came out bleeding, but nevertheless he gave a judgment in favour of the husband. The wife got a worse outcome in raw dollars than the last offer, and then she had a legal bill of about $140,000, which of course she never paid. When the judge read out this judgment, both parties were present in court. They walked down the court aisle, and as they walked down, the wife turned to the husband and said, "Now it's payback time." They walked out the door. The husband turned right with a big team of his supporters and his lawyers. They had a huge party at the law firm. The law firm had this tradition of celebrating wins. Chinese community poured in. The wife turned left. She walked down in this big city, and she walked to a large office. And what was it called? The Medical Registration Board. She walked into the front counter and said, "I have a complaint to lodge against a doctor." They gave her a form. She filled in the form. First sentence, "My husband performed an abortion on me in the house." Second sentence, "He is sending drugs to Hong Kong to look after his sick relatives." Signed. Hearing 3 months later, the husband was struck off. The Chinese community refused to have anything to do with him again. His photograph appeared on the second page of a newspaper for a moment in time. So what were his life goals if they were ranked? Life goal number 1, to be respected in the Chinese community. Life goal number 2, to have a medical practicing certificate. Life goal number 3, to earn $8 million as a practicing specialist surgeon. Life goal number 59, not to pay my wife $40,000. Life goal number 59 trumped 1, 2, and 3. But the law firm didn't have a whiteboard, never prepared risk analyses. They won the case and destroyed the client's life because they had not developed the risk analyses. We could talk about the case more, but remember the key phrase from the wise elders, that behind every great fortune is a great crime. And all wealthy people have dirty washing. And your job as a lawyer is to find that. So in this case, who knows your dirty washing? Those who are intimate with you, in this case it's a wife. So there are always risks which you need to dig out and then have a structured settlement so that people don't blab over the next 10 years when they get their $10,000 check on Christmas Day for the next 10 years. Okay, so that's risk analysis. Please go back and work on it in your files, and we'll see you for the next talk next year. Thank you.